U.S. Supreme Court case dealing with driving while license suspended. And it had to do with a warrant. Apparently a warrant was recalled, but the system was not updated. But it was a court clerk that had failed to notify, notify about the recall of the warrant. And so the reasoning of the Supreme Court there was that the police officer has no choice but to operate under a good faith reliance on what's being reported to them in the system, and that that they can't be expected to be held responsible for a court clerk's mistake. In Mayorga, it's a police dispatcher, and in that respect, the Mayorga court decided that because it's a police dispatcher making a mistake, then the evidence should be legitimately suppressed. In White, I'm trying to identify precisely what the mistake was. I tell you that White declined to engraft the Evans distinction between errors committed by law enforcement and those committed by judicial personnel. It was very explicit in that regard, and they cite a footnote in the Supreme Court that says that the law enforcement personnel distinction wasn't technically before them. Even though all their reasoning finds it important, they didn't expand their holding to extend to law enforcement personnel explicitly. But however, the reasoning that they use all applies to court personnel. Let me just clarify what the White case was about real quick. A member of the Bexar County Sheriff's Department called his counterpart in Harris County. During this conversation, it was learned the warrant had been recalled, but this information had not yet been entered into the computer system. And therefore, they arrested him on a warrant, and they found some marijuana. Don't release a jury yet.
Okay.
All right, I'm going to go ahead and sustain the defendant's objection. So, evidence, really all the evidence after that is admissible. Okay? So,
instead of going through the rigmarole of a direct verdict, I'll make a motion to dismiss the case.
sounds good. Yep. Beware, Mr. Diaz. The state might appeal this one.
Actually, doesn't the law state that?
What do you do with these non-record courts?
No, it can't. From the state perspective, we can't.
You don't have a right to appeal from a non-record court. I said,
Well,
okay, if it was a record court, then they could.
Yeah.
Okay.
Would be an interesting issue, though, to explore.
I can see both sides to it. I really could. Dealing with the rationale of the exclusionary rule versus the source of the fault.
I agree.
Ladies and gentlemen, thank you for your patience. Everything is, the case has been disposed of. And so we appreciate your patience as we had to nail down some legal matters which you might be able to speculate on after the testimony that you heard in terms of the mistaken information. That was the basis for pulling the individual over. So the case has been resolved at this point. So we very much appreciate your time. We know you sat back there for a good, 45 minutes, or was it longer? We definitely not trying to be insensitive of your time. It was a sacrifice for you to be here. So thank you very much for taking your jury summons seriously. And you are now released. You can talk about this case to each other or the press or anyone else?
Your Honor, can I address the court before? This is basically what I've been talking about. It's just going to be dismissed, and it's not going to clear anything up.
We'll deal with that in just a second. But I want to go ahead and release the jurors.
Well, can I say something before they're released?
What's that?
Can I say something before they're released?
If you want.
I want to keep it as public as possible.
Go ahead. You don't. I can tell you this: that this is a public forum, and he's expressing some of his concerns. You don't. You are released if you want to leave. You can, but if you want to stay and hear,
Yeah, y'all don't have to stay and
Mr. Diaz
listen.
has to share, you're welcome to. Go ahead.
Now that you've motioned for a dismissal, it states that the state cannot appeal after it's been dismissed, correct?
Correct.
What about me?
What it means is that this particular case has been dismissed based on decisions that we explained earlier.
And but like I was saying, it doesn't clear anything up.
And unfortunately, the only way you can ever get clear is to get straight with DPS. And I know it's a nightmare. I deal with that in my day job, dealing with the DPS bureaucracy. But you got to get straight with them, whether that's payment plans or whatever. But that's the only way to fix it. There's nothing Domball can do to fix that problem.
Is your concern with DPS's indication that your license is suspended, and you believe that indication is erroneous? Is that
Everything comes from the citation that I received from here, the false conviction that I received from Tomball.
Did you go to trial on that case?
That one was a conviction. I had received a speeding ticket, and then I didn't have my card with me. I have shown the court several times. Before they go, I would like to state that I do motion for an appeal. Right now I'm motioning for an appeal because driving with license suspended,
You have another pending charge too.
But it's...
Well, look, I can tell you there is nothing to appeal because the case is gone in your favor. So there is nothing to appeal. I will tell you just as an aside, if you've been convicted already for no insurance, whether you pled guilty to that or whether you took it to trial and lost, you have a right to appeal that decision if you took it to trial. You wouldn't have a right to appeal it if you just pled guilty and made a deal and paid it. But if you took it to trial and lost, you had a right to appeal that charge. It would actually be a de novo trial in a county court, which means you wouldn't even have to show a legal basis for the appeal. You would just ask for it. Okay? But if you chose not to exercise that remedy, Mr. Diaz, then that conviction gets reported to DPS, and therefore a surcharge, and then you have all the surcharge issues. Is that, and I assume that may be why your license was suspended, is because you failed to pay the surcharge?
Well, yeah, because I refused to pay the surcharge. Once I found where the problem was, that I had, they came into my cell and had me sign the plea. It wasn't in a court. I was
informed of your rights?
I was under duress. And yes, I was informed of my rights. And I explained to them that I did have insurance, and I showed my insurance. And they gave me time served on it anyway, even though I had shown them. And then I came back since then and shown that I had insurance on that time. The complaint that I had received for that came from an officer named F.T. Mitchell. But the citation was from an officer Plagens, who just weeks prior to that citation had been suspended for honesty, integrity. He had turned cameras on and off during an arrest. And
I don't want to get into all the details because I don't know if there's in the future, if you have another traffic ticket trial and I end up being called to be the judge in the case. I don't want to be so embroiled in your side of the story that I'd have to recuse myself because I would no longer be partial. You understand what I'm saying?
Well, kind of like with Walker, she I don't think she could have been the judge in this case because of the
Well, I don't
issue
know,
with the
but
warrant.
what I can tell you, what I can tell you is just as an aside, because I know that it wouldn't be a legal issue that we would be addressing at trial, and so I'm telling you that whatever, if the suspension arises out of a previous conviction, the legitimacy of that conviction is not going to be an issue in a trial for a suspension arising out of that conviction later. If you want to fight that conviction, if you believe that that conviction was unjust, then you have an appeal process to do it. Now, apparently you pled to it. You're saying you were under duress. You could talk to an attorney. There are some, what they would call extraordinary remedies, that's literally the legal term they call it, for trying to overturn a plea. It's very difficult to do, but you could certainly talk to an attorney about the possibility of trying to do that. And there are much less, the time constraints on that are a lot less. In other words, if you had taken it to trial and lost, you would have a certain time period in which you have to appeal to a county court, or you wouldn't have that option. On these extraordinary remedies, if you are arguing that the plea was involuntary or under duress, and in some sense you think you have a legal basis because of the violation of your constitutional rights to reverse the plea of guilty, which it sounds like is what you're suggesting, there are certain types of remedies. It's a difficult uphill battle. I don't want to deny that to you.
It's been
But
6 years already, so.
you can certainly talk to an attorney about that. But what I'm telling you is that that's going to be, that's an issue that you would raise in terms of challenging that conviction in those appellate processes. It's not something that's going to be relevant here on the suspension arising out. Does that make sense? I'm trying to do my, I'm trying to do my best to give you my sense of it, because, you know, I don't want you to feel like you're being railroaded or anything, but the fact is you just got your case dismissed.
I wasn't really aiming for dismissal. I wasn't really aiming for a dismissal. But
Good luck, Mr. Diaz. I would suggest that you take care of what you can up down there in Detroit.
thank you, Your Honor. Got around a machine.
That wasn't a lot, that's why.
See you next time. February 21st, 2013, 5:18 p.m.